At the conclusion of this lecture, you will be able to understand and explain the doctrine of privity, and distinguish the presumptions relating to intention to create legal relations. The doctrine of privity means that a contract cannot, as a general rule, confer rights or impose obligations arising under it on any person except the parties to it. There are a number of reasons behind the doctrine of privity. First, as a contract is based on mutual agreement, it would be unfair to impose obligations on a party who may not have given his consent to be bound. Secondly, a third party to a contract will not have provided consideration to support the agreement. Thirdly, privity avoids allowing third parties to restrict the rights of contracting parties to amend or abandon their agreement. The following three cases provide practical understanding to the doctrine of privity and the reasoning behind the doctrine. Wilson v. Darling Island Stevedoring Company, Price v. Easton, Tweddle v. Atkinson. There are a number of ways in which consequences of the application of strict rule of privity may be avoided to allow a third party to enforce a contract. These occur at both common law and under statute. We will now examine the common law exceptions. Exception of agency. Agency is a legal relationship between two people, where one of them, the principal, gives to the other, the agent, the authority to create legal relations between the principal and the third party. If the agent acts within his or her actual authority, such act will bind the principal. In other words, the principal can take action in his or her own name to enforce the contract made by the agent or become personally liable should the contract be breached. The relevant case here is Scruttons Limited versus Midland Silicones Limited. A trust is created where a trustee holds property on behalf of a beneficiary. The trustee holds the legal title to such property subject to the interest of the beneficiary in such property. A promisee will be regarded as a trustee of a promise if it was the clear intention of that party at the time of the contract was entered into. Whether a trust is created will depend on a true construction of the terms of the contract and the intention of the parties. In deriving intention from the language that the parties have employed, the courts may look to the nature of the transaction and the circumstances, including the commercial necessity of the arrangement. The intention required to create a trust need not be held by both parties. It is sufficient if the promisee alone holds the intention. See the case of Trident v. McNeice for a practical understanding of this issue. Restrictive covenants may, if certain conditions are satisfied, run with the land and bind purchasers of it to observe the covenants for the benefit of adjoining owners. See the case of Tulk v. Moxhay for a practical understanding of this issue. Where it is foreseeable that damage caused by any breach of contract will cause a loss to a third party. See the case of Linden Gardens Trust Limited versus Lanesta Sludge Disposals Limited for more information on this point. Collateral contracts are a contract between two parties. They may be accompanied by a collateral contract between one of them and a third person relating to the same subject matter. There must be an intention to create a collateral contract before that contract can be formed. There is a valid assignment of the benefit of the contract. A party to a contract can transfer the benefit of that contract to a third party through the formal process of assignment. The assignment must be in writing, and the assignee receives no better rights under the contract than the assignor possessed. The burden of a contract cannot be assigned without the consent of the other party to the contract. There have been changes in the law to allow those to claim what was supposed to be for someone's benefit. The Contracts Act 1999 has made changes that allow rights to third parties. Section 1 of the Act provides that in order for the third party to gain rights of enforcement, the contract in question must either expressly confer such a right on them, or, alternatively, it must have been clearly made for their benefit. The contractual agreement must actually identify the third party, either by name or as a member of a class of persons, or answering a particular description. The third person need not be in existence when the contract was made, thereby making it possible for parties to make contracts for the benefit of as yet unborn children. A contract does not exist simply because there is an agreement between people. The parties to the agreement must intend to enter into a legally binding agreement. This will rarely be stated explicitly, but will usually be able to be inferred from the circumstances in which the agreement was made. In the case of ordinary commercial transactions, there is a presumption that the parties intended to create legal relations. The onus of rebutting this presumption is on the party who asserts that no legal effect was intended by the agreement. Many social arrangements do not amount to contracts because they are not intended to be legally binding. Equally, many domestic arrangements, such as between husband and wife, or between parent and child, lack force because the parties did not intend them to have legal consequences. See the case of Balfour versus Balfour. Note the general rule on social and domestic agreements remains since the recent Supreme Court in the UK's decision by allowing prenup contracts to be legally enforceable. Additionally, an agreement which is made subject to contract or a letter of comfort is generally unenforceable. The words normally negate any contractual intention, so that the parties are not bound until formal contracts are exchanged. In conclusion, the Doctrine of Privity ensures that third parties cannot enforce a contract they are not a party to. Exceptions to the Doctrine of Privity are numerous and include the Statute of Contracts Act 1999. There must be an intention to enter into legally binding agreements before a contract will be enforceable.